Mediation. Employment Problem Resolution System. This is the Employment Problem Resolution System. The matter might be resolved at any point in between each stage. Mediation under the Employment Relations Act. Mediation is a voluntary process where an independent mediator helps parties to work through issues and develop solutions together. Employment Mediation Services provides a free mediation service to any employee or employer with an employment relationship problem. It's confidential and without prejudice. It's voluntary but can be directed by the Employment Relations Authority or the Employment Court. It's usually carried out by mediation services mediators who are experienced and neutral. They do not work for either party. Because it is voluntary, parties do not have to agree to attend unless ordered by the authority or court, and the parties do not have to reach any agreement during the mediation. It can result in a legally final, binding and enforceable agreement. MBIE mediation services are free. Requests for mediation can be online. Most requests for mediation are actioned within 2 to 4 weeks. Urgent cases are actioned within days. Mediations can be about personal grievances and individual issues. Mediations may be for problems in an ongoing employment relationship or after the relationship has ended. Mediations can also assist in the collective bargaining and when there is a strike or lockout notice. Mediators work with employers, employees and unions and be focused on helping the parties reach an agreement that will resolve their particular employment problem. Employment Mediation Services mediators are neutral and independent, are engaged by the Ministry of Business, Innovation and Employment and subject to performance criteria. Mediators primarily carry out mediations to assist parties to reach their own agreements. They can also make a recommendation which, if not rejected by either party, is final and binding and enforceable. If the parties agree, can exercise the power to make an enforceable decision which can't be appealed, are subject to a professional code of conduct and are members of professional bodies. Mediations. Dispute resolution coordinators organise mediations, liaise with parties and explain the mediation process to them. Mediations typically take between 3 and 4 hours for a half-day meeting. A full-day mediation can take up to 8 to 10 hours. Parties may be represented by lawyers or advocates. Stages of mediation. These are the stages of mediation: pre-mediation, mediators opening, parties presentations, discussion or mediators questions, thinking about options, negotiation phase, drawing up agreement, checking agreement, signing agreement, and closing. Why mediation is successful. Most cases that come to mediation are resolved, 75 to 85%. Mediation is usually successful because it allows parties to determine the outcome rather than having a decision imposed on them. It's a confidential process. Most representatives are committed to resolving cases at mediation. Parties can generally get a better outcome than going to court. Litigation is different because of the emotional costs and stress to both parties and the low levels of monetary awards set by decisions of the authority and the courts, and because of the high costs of representation in litigation. Mediation information. Visit our website for more information and to download the following publications: Mediation Workbook, Preparing for Mediation, Using Mediation Services Effectively, and Mediator Code of Ethics.